afternoon. We'll start panel 39, advisory function of the rule of law. I'll give the floor to our moderator, Ms. María Fernández, María Teresa Fernández de la Vega. Good afternoon. It is an honor for me to participate in this World Law Congress in order to talk about the Supreme Advisory Councils, institutions that, despite of its long-standing tradition, they're not well known even through legal operators. I would like to thank Javier Cremades and all of the organizers, and also to regret not being able to go to that wonderful country that is Colombia due to the evolution of the pandemic, and due to the fact that it was possible to participate virtually. I decided to apply the caution principle and to stay in Spain. It is a great. I'm really sorry. I'm joined by Marta, Nubia, Velásquez, from the State Council in Colombia, and the President of the Council of Luxemburg, Christophe. I would like to, first of all, thank the chair in Colombia and also Mr. Litz, who went to Barranquilla and is there in person. Therefore, we will have a hybrid format for this session. Thanks to technology, I'm sure we will be able to keep a conversation and a dialogue that will allow us to talk about the functions of state councils and the relevance that state councils have in the context of rule of law, the institutions that we represent of different configurations. The Spanish State Council is exclusively of an advisor, part of the advisory function. We share this with the Luxembourg State Council. The Colombian State Council joins jurisdictional functions with advisory functions. I believe that over the or in recent times, the interest in state councils has increased. I think that we can explore the reasons behind this increasing interest. Nevertheless, I think that this is connected or linked to the peculiar aspects of our own institutions. I would like to highlight some of the specific aspects of the Spanish State Council. First of all, this is a historical institution created by Carlos I, Charles I, back in the 16th century. This is one of the oldest institutions of the Kingdom of Spain. First of all, it was linked to the monarchy and then to the constitutionalism. The article of our constitution that defines the State Council defines it as the main advisory body for the government or entity for the government. And it's very important to work at a place where dialogue is a way of achieving results, because the state council is an entity of deliberation that is aside of party line interests. Legal aspects are discussed with elegance and not in a hurry. It seems that time stops for knowledge and wisdom to flow, and for experts to be able to analyze the most diverse aspects that are presented to our institution. The Permanent Commission, which is at the heart of the State Council, is integrated by advisors, both men and women. This is a lifelong appointment, which constitutes a guarantee of independence. Bauman, in its Liquid Modernity, said that the experience of negotiations and the common identity, which is more and more exclusive, had led to a lack of interest in achieving a common interest and a pact from that common interest. Bauman also mentioned the substitution of the mutual commitment for techniques of escape. As you can see, I preside over an institution that it's not affected by this pathology, but that looks for solutions to these problems that Bauman mentioned. In the State Council, we discuss, we enter a dialogue, and we convince each other. I like also the function that we have in our contact with citizens. We have a function of interpreting and applying the demands of the citizens. We are in charge of interpreting laws for guiding political function. Advisory entities or advisory functions. We navigate what is legally possible and what is right in terms of decision making. The State Council is based on the norms that are part of our legal framework, but also on criteria of opportunity or convenience if the matter calls for it, or if it's requested by the authority, by the consulting authority. This same considerations and this same study is the depth that we need to allocate to each one of the issues. Every week, we prepare in great detail the Thursday sessions. The expert and the advisors work on each session with the same reason, with the same level of detail. Whether it's something related to an economic issue or a royal decree or ratifying an international treaty. Another particular aspect of the State Council is that we're an actor of revision, of privileged observance in order to ensure the proper working of public services. We can warn about threats and dangers in terms of public services and their provision. And let us not forget that when we discuss public services, we're talking about the materializing social rights. We're therefore at the service of the compliance with these rights. And I wouldn't stop without referencing the council that coexist with the consulting councils from our autonomous regions in a decentralized model, which corresponds with the territorial organization or division in Spain. Right now, we have a number of autonomous regional councils that coexist with this with our state council. We've on our this have coexisted for over 2 decades now. From autonomous communities, there has been a great diversity in terms of the advisory function, and they have been able to get this exercise closer to the citizens. And this proximity is the result of the effort and the capacity of self-government of our communities. Without this, the volume of work of the council that I preside would be multiplied by 7, to say the least, which gives you an idea of the amount of work that we have. These are heterogeneous entities. So after this very brief presentation of the Spanish State Council, I would like to give the floor to the chairs joining me in this session, dear Chair of the State Council of Colombia and dear Chair of the State Council of Luxembourg. I would like to ask you to please present the work in your corresponding institutions and to please highlight the aspects or talk about the aspects that highlight the relevance of your function. So let us start with you, Chair of the State Council of Colombia. You took this position back in January. So congratulations. You would be you were a former auxiliary justice, but what can you tell us? Well, thank you very much, Ms. Teresa Fernández de la Vega. I would like to also welcome the chair of the State Council of Luxembourg, Christophe Schiltz. Yes, I was not only an auxiliary magistrate, but also I, I would like to say many things. Let me start by telling you, or to talk about some of the story of our consultation room and civil service, which works in this advisory function. So this body that I have the honor to preside does not have the just the advisory function, as Maria Teresa mentioned, but also some legal and jurisdictional functions, since it's the highest court in the contentious administrative in Colombia. And as chair, I also chair. So we have the consultation division, but the chair of the state council also presides over the whole body. So this double condition means that, well, Colombia, it's an exception since we have this double function, just as some other countries around the world have. The birth of the state council comes from October 1817. It was created by liberator Simón Bolívar in the city of Angostura. And it's important to mention the point of reference for Simón Bolívar was this French State Council created by Napoleon in 1879. That was the point of reference for Colombia. The functions and the integration of this State Council are different from the ones that we have right now. And the institution was called back then the Provisional State Council, and its function was to basically propose and discuss and agree on important provisions, laws, regulations, or about institutions. All of which needed to be published for the correct organization of the provinces that were liberated. This was made by military, civilian leaders, and it had three sections: the Trade and Finance Council, the Marine and War Council, and the Justice Council. Back then, Colombia was in the middle of this process of independence and was soon to be a republic. So the liberator tried to prevent not only did he give these functions to the state council, but it also wanted to, the council to help prevent some arbitrary actions during this process. His intention was that while a constitution was agreed upon, everything would go through this state council, and due to the dignity of its members, this body should be trusted by the people. This institution remained a consultative or an advisory entity throughout the constitutions of 1821, 1830, 1832. And with the organic decree of 1828, it became part of the structure of some states or republics. This and lasted with the constitutions of 1858 and 1863. It was elevated to a constitutional body in 1886, and among other functions, it was deemed as the main advisory entity for the government for everything related to administrative topics. And even though the superior text said that the majority of its mandates were not mandatory for the government, there would be for specific cases such as pardons and life sentences and reduction of sanctions. It was also mandatory the approval of agreements when the Congress was at recess, the transit of international troops, and the passage of ships, of international ships in territorial waters, and also for the approval of extraordinary credits in given circumstances. this also added the function of allowing for extraordinary circumstances or extraordinary circumstances measures due to the nature of our history. Uh, some institutions were eliminated. Back in 1905, the state council was eliminated. Uh, and the reason behind it is that the government said that they wanted to rule without any blockades. And they considered the constitution as a uh, useless gear in public administration. Once the government of President Reyes ended, Law 130 of 1913 and the amendment of the Constitution of 1914, and this reestablished the State Council as the superior advisory body of the government. Our State Council was divided into two sections. One is the general business or general affairs section, which was formed by what we still have, in the figure of the vice chair and two people appointed or two members appointed by Congress. And the other section was the contentious administrative section with four advisors that were appointed by the executive power. Today, our consultation section has four advisors, and the contentious administrative section has 27 magistrates or justices. Law said that the State Council would meet to discuss public order or extreme situations whenever this was deemed necessary. In 1969, it was necessary for the country to approve a political parity, and the executive power was deemed completely independent. And the advisors were, it was decided that it the advisors would be a lifelong position. It is very important for consultative or for advisory function how this, and one of those things is that the civil service section was created. Other laws that came afterwards also strengthened our advisory function. So much so that once again, the State Council was deemed the superior body, the advisory body for the government. There was something very important for a recent history, and it was the issuance by the uh, National Constitutional Assembly. It really institutionalized this entity, this body. It determined the definitive division into sections and rooms in order to divide the different, divide the advisory functions from the jurisdictional functions. So this has determined that the State Council is the main advisory body of the government, but also one of the main jurisdictional bodies in or the main jurisdictional body. So each one of our sections are separated according to their specialty. So the law that rules us right now develops our functions on the both the advisory and the contentious administrative functions. It's very important to mention that we have very important functions, like address any consultation that's specific from the government. As Maria Teresa, you mentioned, we only have one state council that deals or addresses consultations from the national government. Also, we also review draft laws and codes. We review also compilations of regulations and any topics of interest for public administration where it's deemed necessary. Recently, an opinion was requested in terms of the political discrepancies between territorial and national entities. We're also in charge of determining whether candidates for the president or to become president of the republic meet the requirements or not. Also, are the ones in charge of establishing whether different religious movements comply with the conditions to be deemed so. I would like to mention here that the concepts of the consultation section are not mandatory and that are part of the legal or the 6-month legal reserve. So our advisory civil service section, it's very important because we solve current conflicts. And in the contentious administrative, we have our contentious administrative section, of course, solving different issues depending on their specialties. Okay, I'm sorry, Terry, we ran out of time. Well, thank you very much for your intervention. We're really behind. There are many things that we want to mention now. We're going to change continents and we're going to Luxembourg. The State Council of Luxembourg currently has functions that are exclusively of advisory, just as the State Council in Spain. So, dear Chair, you now have 10 minutes to tell us about the functions of the State Council that you preside and its relevance. So please go ahead. Bueno, muchas gracias. Desafortunadamente debo hablar en inglés. Mi español no es lo suficientemente bueno para dar una presentación acerca de este tema en español. Quisiera agradecerle a los organizadores por invitarme y por organizar este evento. Yo creo que este es un tema muy importante y me alegra que podamos tener este intercambio acerca de estos temas. Muchas cosas interesantes han sido dichas ya acerca de mis colegas que me precedieron acerca del rol consultivo. Yo quisiera hablar algunos de los temas más relevantes que tienen que ver con el Consejo de Estado de Luxemburgo. El sistema político en Luxemburgo tiene algunos rasgos específicos que tienen una influencia sobre el rol del Consejo de Estado. Nosotros solo tenemos una cámara en el Parlamento, no es bicameral, y esto tiene una influencia sobre el rol del Consejo de Estado. Esto quiere decir que el Consejo de Estado tiene un rol más fuerte que ejercer en un sistema unicameral como el nuestro. Como saben, nosotros somos un país muy pequeño, todos nos conocemos entre sí. Bueno, realmente no, pero ustedes me entienden. Nosotros somos una institución independiente, pero existe una interacción y unas conexiones cercanas con otros cuerpos y con el Parlamento también. Hay algunas características específicas del derecho en Luxemburgo que tienen que ver con cómo vemos el Estado de Derecho y cómo proteger el Estado de Derecho desde el Consejo de Estado. En Luxemburgo hay una supremacía absoluta de la ley europea e internacional y los principios internacionales. Por ejemplo, hay un marco de la protección del Estado de Derecho en cuanto al derecho internacional y el derecho europeo. Lo segundo es que tenemos la Corte Constitucional, que solo ha estado ahí por 25 años. Pero esta Corte Constitucional también analiza leyes y revisa si, por ejemplo, estas son compatibles con la Constitución y también con principios generales como el Estado de Derecho. Entonces, este es un segundo elemento que protege este Estado de Derecho a nivel constitucional. Luxemburgo, como decía, el Consejo de Estado no ha existido por tanto tiempo como en otros países. Fue creado en 1956 y fue una reacción a la Constitución liberal de 1948. En esa época hubo varias revoluciones en Europa, perdón, en 1860, aclaro, una, una decisión del rey en ese momento y para mantener a raya el Parlamento. Una de las formas era crear el Consejo de Estado. Nosotros solíamos ser, como ya se mencionó, nosotros solíamos ser la corte administrativa más importante y también teníamos el rol consultivo. No teníamos dos divisiones separadas. En, en, en 1997 se dijo que no se podía dar una opinión acerca de regulaciones y después ser juez interpretando esas mismas normas o como ya mencionaron quienes me antecedieron, hubiéramos podido crear dos secciones diferentes, pero la decisión fue separar la causa administrativa o el sistema administrativo y mantener únicamente el rol consultivo en el Consejo de Estado. El Consejo de Estado en Luxemburgo nuestra composición es un poco diferente a la de nuestros vecinos como Francia y Bélgica. Nosotros tenemos 21 miembros. El archiduque es el último miembro. Esto, ellos son nombrados por 12 años y no se pueden ser renovados esto para mantener su independencia. Y queremos mantener esa independencia en términos de, por ejemplo, el Estado de Derecho. Es muy importante, por ejemplo, que los miembros saben que si no dan una opinión sobre esto, no van a ser de todos modos reelegidos. No todos en el Consejo de Estado, no todos los miembros deben ser abogados ni deben tener estudios en Derecho. También hay una regla de género, al menos 7 de los 21 miembros deben ser del género menos representado en el momento. En este momento sí, creo que tenemos 9 mujeres y 12 hombres. La elección de los miembros del Consejo de Estado no se dan en términos de la rotación del gobierno, el Parlamento. Nosotros como Consejo de Estado decimos necesitamos tal y tal perfil. Este es el perfil que necesitamos para nuestro próximo miembro. Debe tener estas cualidades y después va a terminar ya del gobierno, del parlamento o de nosotros mismos encontrar a tal miembro. Pero esto viene de una reforma del 2017, pero debe haber una conexión partidista, ya que la composición del Consejo de Estado debe reflejar también la composición del Parlamento. Entonces, hay cierta influencia política en las nominaciones, pero tratamos de mantener nuestro trabajo tan legal como sea posible. Entonces, ¿cuál es nuestro rol exactamente? No es únicamente consultivo. También tenemos un rol en términos del proceso legislativo, contrario a otros consejos de Estado. Perdón, se está cortando el micrófono. Nosotros emitimos nuestra opinión acerca de proyectos de ley, también proyectos de normas del gobierno, pero no solo las emitimos al gobierno, sino también al Parlamento. Entonces el gobierno, cuando adopta un proyecto de ley, y nos lo envía a nosotros, pero también al Parlamento. Nosotros no nos involucramos en la producción del texto, solamente damos nuestra opinión una vez se ha acordado ese texto y es enviado al Parlamento. Entonces, nosotros no somos un cuerpo consultivo únicamente para el gobierno, pero también para el Parlamento. El Parlamento, igual que el gobierno, puede adoptar las modificaciones a las leyes nos lo envían a nosotros. Entonces, de nuevo, no estamos estrictamente conectados a los gobiernos. Nosotros aconsejamos al Estado, es decir, no solo al gobierno, sino también al Parlamento. ¿Y cómo lo hacemos? Lo hacemos examinando estos proyectos que recibimos. Revisamos si las disposiciones que están incluidas en esos textos son compatibles con la Constitución, con tratados internacionales y con principios generales. Por ejemplo, el Estado de Derecho, los derechos humanos. Esa es la parte consultiva. Tenemos un rol que jugar también. Nosotros debemos que el Parlamento debe votar dos veces. Debe votar una vez por un texto y a los 3 meses votar sobre el mismo texto. Pero también pueden decir, nosotros no queremos votar la segunda vez, no queremos esperar los 3 meses. Y ustedes conocen a los políticos, ellos no necesariamente quieren esperar a que una ley entre en vigencia. Ellos pueden decir, no queremos esperar los 3 meses y nosotros como Consejo de Estado debemos dar nuestra aprobación para que ellos no deban votar de nuevo. Entonces tenemos una suerte de poder de veto. No, si nosotros decimos sí, no se debe votar de nuevo, la ley puede entrar en vigencia. ¿Y cuando decimos que no es necesario votar una segunda vez? Solo lo decimos si pensamos que la ley es compatible con lo que ya mencionamos, con la Constitución, con los principios legales. Entonces, nosotros podemos decir, este proyecto de ley no es compatible con el Estado de Derecho, entonces estamos en desacuerdo con que ustedes voten una sola vez. En práctica, yo he sido miembro del Consejo de Estado desde el 2013 y lo he presidido desde abril este año. Y fue en estos 8 años en el que he sido miembro, solo ha sucedido 2 veces que el gobierno vote 2 veces en una ley. Ellos no estuvieron de acuerdo con lo que nosotros dijimos y ellos no cambiaron el texto del proyecto de la manera en la que sugerimos. Entonces, tenemos un rol importante porque en general ellos siguen nuestras recomendaciones y los cambios que nosotros sugerimos. Pero obviamente esto es un diálogo. Nosotros no decimos esto tiene que hacerse de esta manera. Simplemente hay un diálogo. Esta mañana no pude estar en la sesión inaugural porque estaba en una conferencia con el ministro de Salud acerca de un proyecto de ley y tuvimos que hablar de cómo nos oponemos a un impuesto que ellos proponen. Entonces sí hubo un diálogo acerca de esto con el gobierno, pero nuestro rol en el proceso legislativo no es únicamente consultivo, también jugamos un rol a través de nuestro veto. Nosotros, por ejemplo, también examinamos principios generales. El Estado de Derecho ha sido determinado como un principio constitucional. La Corte Constitucional también ha reconocido otros principios que se derivan del Estado de Derecho, como la certeza legal, el principio de la no retroactividad de la ley, el principio de la legalidad, de la proporcionalidad. Entonces, adoptamos estas decisiones de la Corte Constitucional o las tenemos en cuenta cuando emitimos nuestras opiniones, porque esa es nuestra misión constitucional, verificar el cumplimiento de cada proyecto legislativo o regulatorio con leyes de mayor orden. Un último elemento que quiero mencionar en cuanto al rol del Consejo de Estado y la protección del Estado de Derecho es lo que nosotros llamamos en nuestra constitución y que yo estoy seguro existe en otras constituciones, son los asuntos reservados. Esto quiere decir que ciertos temas y ciertos asuntos en la constitución deben ser manejados por ley. Por ejemplo, la protección de los derechos de los ciudadanos. La educación es algo en lo que por ejemplo, el gobierno tiene que presentar una ley y nosotros como Consejo de Estado podemos opinar y a través de nuestro veto podemos influenciar y proteger el Estado de Derecho para estos casos. Entonces, para concluir, el Consejo de Estado tiene un rol crucial en cuanto a la protección del Estado de Derecho. Nosotros tenemos un rol consultivo, pero también estamos involucrados en el proceso legislativo y tenemos derecho a un veto suspensorio y la protección del Estado de Derecho. Lo hacemos a través de la protección de los principios legales fundamentales. Nuestro análisis. Gracias. Muchas gracias. Thank you very much, Mr. President. I think it's time to open the floor for any questions that we may have. I don't know if we have. So at the time, we don't have questions in a room. So I don't know if as moderator, you have any comments. Yes, I wanted to ask something additionally to both the presidents. I think that it's a very important topic at hand. Let's look to the future. We're all talking about the future as it's obvious and logical. I would like to ask you, what are the greatest challenges that we face in this new society in terms of our advisory role, for instance, or advisory function? How did you manage as presidents in the case of your institutions the demand for transparency and the need of working in your deliberations? Did you regulate it, the publicity of your decisions? This is something that I wanted to ask you because I think that this is something that it's quite relevant. So, President of the State Council of Colombia, if you'd like to start. Yo puedo comenzar. Esta es una pregunta interesante, la que tiene que ver con la transparencia. Todas nuestras. Oh, I'm sorry. I think my mic was off. President of the Council of State of Colombia, we didn't hear you. I'm sorry. I think they silenced my microphone. I was saying that by regulations or if advice is reserved and this can be lifted by the national government. This can stay for 4 years. So every consultation is published. It's part of our rapporteuring system and it's available to the public, but yeah, they also have a legal reservation. So in terms of transparency, you were asking, yes, it's a transparency, but one that's restricted by law. And you were asking about how fast it is. Our consultation section gathers every week and discusses all sorts of topics. We also have hearings where we discuss with the different stakeholders and then issues an opinion that even though it's not mandatory, it has become a very important opinion in our country, which is a guarantee of not being partial. Thank you, President of the State Council of Colombia. No, President. En Luxemburgo, todas nuestras opiniones son públicas y siempre lo han sido. Al comienzo eran publicadas cuando el gobierno enviaba una ley al Parlamento. En el pasado le dábamos nuestra opinión al gobierno, pero como ahora es parte del proceso legislativo, todas nuestras opiniones son publicadas tan pronto las enviamos al Parlamento, al gobierno. Pero en lo que tiene que ver con la transparencia, esto es algo que discutimos a menudo en Luxemburgo y esto está atado a la legitimidad del Consejo de Estado como institución. Y a la legitimidad democrática del Consejo de Estado como institución. Porque muy a menudo surge la pregunta en la cual las personas dicen, bueno, usted ha sido designado, no ha sido elegido porque tienen este rol en el proceso legislativo. Debería saber qué miembro votó, en qué sentido, en cuanto a las diferentes opiniones. Una respuesta a eso en Luxemburgo es que en general nosotros no votamos, sino que intentamos llegar a un consenso a través del diálogo en nuestra institución. Otro aspecto es que nuestra legitimidad se deriva de la calidad del trabajo que hacemos y la independencia de ese trabajo. Si se supiera quién votó, por qué, en cuanto a las diferentes opiniones, la presión externa aumentaría y las personas cercanas a un partido probablemente serían obligadas a tomar decisiones a nivel del Consejo de Estado o a votar de cierta manera. Y nosotros intentamos evitar esta influencia externa. Nosotros siempre decimos que la transparencia es importante, pero la transparencia no puede ser transparencia solo porque sí, sino que esta debe llevar o debe mejorar la calidad de nuestro trabajo. Y en cuanto a la velocidad a la que emitimos nuestras opiniones, esta es una pregunta que obviamente surgió durante la crisis del COVID. Las mayorías de las reglas en Luxemburgo que restringían las libertades se dieron a nivel de ley. Pero entonces ellos nos enviaban eh, eh, una un proyecto el viernes en la tarde, nosotros redactábamos durante el fin de semana y damos la opinión el martes. Esto es bastante rápido. Sin embargo, no, nos dimos cuenta, o sea, por la situación debía hacerse así, pero nos dimos cuenta que al gobierno le gusta mucho tener estas opiniones rápidamente, no solo en el contexto de la crisis del COVID, sino sobre otros asuntos. Ustedes, como bien saben, se necesita tiempo para considerar estos temas y no se deben apurar las opiniones porque la calidad de la legislación puede sufrir si se hace de esta manera. Thank you very much, Mr. President. So these topics that we're discussing remain topics of great concern, both that of transparency and the one of decisions or deliberations. Ever since I became president of the Council of State back in 2018, to me, transparency and openness have been priorities. I was aware that we had to work towards that direction, but we had to do it by protecting institutions. Our organic law in Spain establishes the obligation of publishing a yearly memory in which we include a selection of the more relevant opinions. Now we're making these opinions more accessible. Back in 2019, we called on the first press conference. This had never happened before, so we called on the media. we've had 3 meetings with the members of the media, and I think that it's important to educate regarding the function and how our institution works. An institution that people know very little about. I think that not only in Spain, but everywhere else in the world. And it's only through that education that we can try, and only try sometimes, to avoid our opinions for being used in the political debate in a fragmented way in order to stoke the flames of political debate. So our opinions are not regulated. And that's why we publish this selection of our opinions. But we also insist that it is the government or the consulting authority, the one that this should decide when these are published. And we also consider that it should be possible to publish this when the legislation was already published. The members of the council are there's a mandate to keep the secret of the consultations before issues are solved. Nevertheless, we don't have a regulation that states when issues are resolved. I would like to hear from you how it works. So when is it solved? When it's published? When it's there? Also, some files over which the council acts on a pre-contentious stage, let's say, and we give opinions about whether there's room for a economic or financial claim by the state. We intervene in any claim that's over 50,000 euros. We also make sure that the anonymity of the parties is protected. I also talked about our coexistence with the regional autonomous advisory councils. These advisory councils have applied varied mechanisms that can work as reference for us. And I think that we have to keep in our mind the best interest of citizens, because it's very important that for citizens to be interested in the topics on which the Council of State is providing an opinion on. The relevance should not depend on whether these are published or not, or before they are approved or after. Even though I'm convinced that we need to increase transparency and to open the doors of our institutions, I'm not sure, and I would like to know your opinion, if we have enough time, that we should allow for us to be influenced by the demands of the media in current times, because the media always wants to know what our decisions are, and our times and our pace is probably slower than the one that they demand from us by the media and other stakeholders. Therefore, if you would indulge me and answer, Presidents, could you discuss a little bit about these 2 questions related to publicity? Yes, President of the Council of State of Colombia. So in the case of the Council of State of Colombia, the opinions are reserved. Publishing depends, and publicity depends on the government. Yes, we have some publications, but we have a legal reservation. That's the first thing that I wanted to mention. And in that related of being overwhelmed, when I heard you at the beginning, I wanted to tell you that our consultation section, they're very calm, and they do not have to endure the pressure from the media that the contentious section needs to deal with, where they have the members of the media constantly asking, where is a project and where is their opinion going. The consultation section has a more academic and more calm function, and typically they are not subject to these kinds of pressures that the contentious section may be subject to. So once again, in terms of the publicity, that's for the government. In that, in terms of draft laws, all of this, it's public, and we present this on behalf of the whole entity, and we're very open in that. Once an opinion becomes public, well, it is published. We have constant press releases, press bulletins, and our press department from the Council of State publishes bulletins permanently that are sent out to the press, making these opinions public. Since we have different systems, our publicity also changes, right? Because we have a lot of pressure in terms of publicity. When we make a decision, we communicate the government, and it is the government the one that makes it public. But that doesn't mean that the media doesn't come after or don't come after us. They come to the Council of State for us to give them a preview of our decision to see whether the government follows our opinion or if they don't. So there's always a tension. We by principle, we don't talk to the media before the government does. When the government talks to the media, then we can explain what we said. Now, President in Luxembourg, how does it work? Bueno, creo que en Luxemburgo es un poco diferente a España. Pero yo pensaría que como nuestro rol es un poco diferente en cuanto a que no somos solo el rol consultivo del gobierno, somos un poco independientes entre el gobierno y el parlamento. Todas nuestras opiniones son públicas, las publicamos el día en el que se adoptan o a más tardar el día siguiente. Entonces nuestras opiniones sobre proyectos de ley, sobre enmiendas o reformas, algo muy importante cuando opinamos sobre la regulación del gobierno. Cuando publicamos nuestra opinión, el gobierno no la había publicado todavía. Entonces, no fue el gobierno el que publicó, sino nosotros publicamos sobre su regulación, la regulación del mismo gobierno. Entonces, de nuevo, el mismo día o el día siguiente, exceptuando cuando el gobierno tiene más cuestionamientos. Por ejemplo, alguna vez hubo una acerca de la disolución del Parlamento y el principio de disolución del Parlamento. Esas opiniones vienen directamente del gobierno. Nosotros se las enviamos a ellos y depende de ellos decidir. Lo que se debe mantener en secreto es muy importante, es el contenido de nuestras discusiones. Yo hablaba de que somos un país muy pequeño, muchas personas tienen contactos con la prensa, pero lo que tratamos es que nuestros miembros del Consejo no hablen acerca de la discusión en específico, quién dijo esto, quién dijo lo otro. Entonces el contenido de nuestras deliberaciones sí intentamos mantenerlo privado. En lo que tiene que ver con la prensa, como nuestras opiniones son públicas, tenemos menos o no tenemos presión de la prensa preguntándonos cuál es nuestra opinión. Pero lo que sí nos preguntan, por ejemplo, cuando publicamos una opinión, nos preguntan cómo debería ser interpretada. Entonces nos piden interpretaciones de nuestras propias opiniones. Y nosotros decimos a su vez nuestras opiniones se pueden interpretar por sí mismos. No vamos a aportar nuestras propias interpretaciones porque un miembro del Consejo puede interpretarlo de una forma y otro de una forma diferente. Tal vez se logró un acuerdo entre diferentes miembros y si se comienza a interpretar de una forma específica se va a dar todo un debate público y a veces la prensa puede utilizar nuestras opiniones y crea todo un embrollo acerca de cómo dijimos que el gobierno estaba equivocado y que deberían hacer esto o no deberían hacer lo otro. Entonces, a veces nuestras opiniones son criticadas por la prensa, aunque terminamos de mantenerlas en un nivel estrictamente legal, pero bueno, el derecho y la política siempre están conectados. Well, yeah, I think that each one of us is subject to our own particular characteristics. But yeah, pressure from the media is always there, and it's logical that that's the case because citizens want to know, even if it's through the media. But yes, we need to keep a certain balance that it's hard to keep actually, and we will need to continue to learn and to maintain this relations with the media to ensure that our institutions remain transparent. We need to bring what we do to the citizens, all the while maintaining the decisions that we should be able to decide when to make them public, whether they become public or not. I think that this is another one of the challenges that we will continue to face. We don't have a lot of time. Uh, Still, I don't know if there are any questions from our audience. So, are there any questions? Yes. Well, so far we haven't had any comments. So we're listening to all of your contributions, which have been very interesting. Well, perhaps in this last few minutes that we have, we could debate if there's any issue that you would like to debate. There's something that I'm interested in knowing. Uh, Whether you have carried out any digitalization process within your entities, because this is something that has helped us keep a more direct relationship by establishing a transparency mechanism before citizens. I can discuss that, but I would like to know if in the councils of states in both Colombia and Luxembourg you have started digitalizing. Yes, in the case of Colombia, yes. We did it little by little, but last year I think that the pandemic situation accelerated this. We have our own digital system. This is a tool that the Council of State produced. The former president was part of the consultation and civil service section, Mr. Alvaro Namen, and he was very much related to this. And I would say that at a very high percentage, not only the consultation section, but also the administrative section work digitally. We send out our opinion digitally, it is signed digitally, and when it's published, it is also done digitally. So I'd say that yes, we have digitalized all of our processes, and now the challenges are related to the new readings and all the challenges of the reservation of information, but yes, and the confidentiality, but yes, we are working virtually and digitally. And for the case of Luxembourg, Mr. President, pues nosotros hemos intentado hacerlo de diferentes formas. En los últimos años hemos intentado digitalizar nuestros archivos, por ejemplo. Esto fue una gran tarea. Lo que intentamos hacer, la presidenta del Consejo de Estado lo mencionó, que como la crisis aceleró todo esto, tratamos de digitalizar nuestros procesos internos, estamos creando una base de datos que nos diga, bueno, nosotros emitimos este concepto sobre tal artículo de la Constitución y esto, para no reinventar la rueda y saber cuáles son los temas a los cuales podemos volver. Y como lo mencioné antes, las reuniones de comité también se pueden hacer de manera remota. Al comienzo de la crisis de la pandemia, esto fue un proceso un poco más lento. Algunas personas estaban más contentas o más dispuestas a utilizar estas nuevas tecnologías de conferencia de video. pero a este punto ya hemos logrado adaptarnos. Lo último que quería mencionar es el sitio web. Nosotros tenemos un sitio web en donde publicamos todos nuestros conceptos. A veces incluso se publican en este sitio web antes de que yo pueda firmarlas en físico. Pero esto es algo que yo solo mencionaría acá y no por fuera de este foro. Well, thank you very much for that, Mr. President. I think we're at the end of our event. We have just a few minutes. I don't know if our two presidents would like to add some final thoughts. I would like to ask you one final question. Would be, what would be your last message for this community of jurists gathering in Colombia? What would be your last message regarding the relevance of the advisory function from the democratic point of view? Because I think it's very important for citizens to be aware of the very important role that they play in modern democracies. They have always played a very important role, but right now we can see that through the advisory function. And I think that this could be a message to our audience. We have highlighted this all along the debate, but I would like for you to summarize this in some few words. So in the case of Colombia, our advisory function, it's a very important one because it's a function that's outside politics. Our magistrates from both sections are not appointed by the government. They're independent. And this forum, which is a very academic forum and a forum of reflection, it's a very important guarantee for a democratic country because these are opinions that are not issued depending on the political climate of the time. A government may like or dislike an opinion, but the advisory function, it's a guarantee for democracy. And also, our administrative section is very important, but both sections feed each other. So both are very important for the work of the other. President, Mr. President. Yo creo que los cuerpos consultivos tienen un rol muy importante que jugar en Luxemburgo, por supuesto, con nuestro sistema unicameral tenemos un rol muy importante que jugar en términos de la protección del Estado de Derecho. La crisis del COVID mostró muy claro que los proyectos de ley se emitían o se redactaban muy rápidamente y se estaba reduciendo la calidad y a través de nuestros conceptos nosotros pudimos proteger los textos y mejorar los textos y proteger así su función. Yo creo que este rol consultivo es muy importante y los ciudadanos deben saber que hay una institución que evalúa y analiza los textos de los proyectos que provienen del gobierno y que este cuerpo está protegiendo sus intereses y también protegiendo el Estado de Derecho. Thank you very much, Mr. President. So I would like to add on what both of my colleagues mentioned, in that the importance of the advisory function will become greater and greater, given the fact that in our stressed out societies, we need democratic institutions that are sound and that are well established, that think, that debate, that listen, and that from objectivity that comes from not entering the party state can advise the governments and institutions in charge of decision making with the best advice possible, from reflection, from experience, and from wisdom of all the members of our councils of state, which I think we need to preserve and enrich day by day. So thank you very much. Congratulations, Ms. President, Mr. President. It has been an honor to share this debate with you. I would like to have a lot more time to discuss many more things, but I think we have run out of time. So I send you a hug from afar, from the distance, hopefully for an upcoming occurrence, COVID will be in the past, and we'll have the opportunity of having this debate closer to each other. Thank you very much. Thank you.